I'm Sabrina. So in this video, my teammate and I will be analysing the significance of the UK Supreme Court's decision in Patel and Mirza and discussing whether this new approach has settled or clarified the law in this area. But before that, we would firstly like to present a short animation on the case of Patel and Mirza.
Hi, I'm Sabrina. So today I'll be talking about Patel and Mirza. In this case, Patel had given Mirza £620,000 to bet on shares in a company using inside information. This agreement amounted to conspiracy to commit the offense of insider dealing. However, the inside information did not materialize and Patel sought to recover the monies, claiming breach of contract and unjust enrichment. The High Court decided that Patel was unable to recover because he had to rely on his own illegality, which the Court of Appeal also applied the no-reliance principle but nevertheless allowed Patel's claim due to the locus ponentiae exception. Finally, the UK Supreme Court dismissed Mirza's appeal and majority decided that the old approach of recovery should not be followed.
So, the law before Patel and Mirza follows the public policy principles established by Lord Mansfield and Holman and Johnson, which often cites the Latin maxim of ex turpi causa non aritur actio, meaning that the courts will not lend its aid to a man who finds his cause of action on illegality, irrespective of the merits of the claimant's claim. However, there were many issues that arose, such as the judiciary wanting to discourage entry into illegal contracts to prevent unjust enrichment of the defendant at the expense of the innocent party while upholding the freedom of contract. The unresolved dispute and disagreement between the judges were temporarily resolved with the emergence of the public conscience test from the case of Tackwell and Barclays Bank. This test looks at whether it would be an affront to the public conscience to allow the claim and also consider whether the decision would encourage criminal behavior or not. However, due to the inconsistent decisions it resulted, the courts in Tinsley and Milligan replaced this test in favor of the no-reliance principle. This brings me to the three defined exceptions laid down by Lord Justice Bingham in Saunders and Edwards to when the innocent party can recover under a contract tainted with illegality. So firstly, where there is no reliance on the illegality to prove right to the property sought to be recovered. This no-reliance principle was laid down in Tinsley and Milligan and its validity was often doubted. In Stone and Rolls Limited and Moore Stephen, Lord Phillips said it is necessary to give consideration to the policy undermining ex turpi causa in order to decide whether this defense is bound to defeat the claim. The second exception is when the claimant is not impaired delicto. The operation of this principle is found in the case of Mohammed and Alaga and Co., where the claimant's restitution claim succeeded because he was less responsible for the illegality than the defendant firm or solicitors, which was assumed to know the rules of the profession. So thirdly, when the locus ponentiae principle applies. In the case of Tribe and Tribe, the father was able to recover the shares from the son because the legal purposes have not been carried into effect. Hence, the Court of Appeal held that the father had timely withdrawn from the illegal transaction. However, although this formulaic approach was problematic, the United Kingdom Law Commission did not recommend any reform. Consequently, in the case of Jativias SA and Bilter United Kingdom Limited, Lord Neuberger expressed the desire for reformulation clarity should occur as soon as possible and preferably by a panel of 9 justices, which is what happened in the case of Patel and Mirza. The UK Supreme Court disapproved of this formulaic exceptions approach and the majority of the judges decided that whether the court should assist or not, courts should consider policy factors, nature and circumstances of the legal conduct, and whether allowing the claim would be harmful to the integrity of the legal system. The UK Supreme Court also decided that the no-reliance rule laid down by Tinsley should no longer be followed, and this new approach is also intended to apply in private law involving the illegality defense. So similarly, Malaysia adopted the English principle suggested in the case of Palaniabat Shatia and Arunasalam Shatia, where the Privy Council upheld the decision of Holman and Johnson and did not allow the father to obtain a retransfer of the lands from his son. So there are many criticisms on the certainty and arbitrariness of this approach might bring, and there is a fear that the trio of considerations will collapse into an arbitrary choice without principled guidance, and if this proves to be correct, we might be repeating the cycle similar to the rejected public conscience test.
The new approach set out by the majority of the Supreme Court was strongly objected by the minority. The decision did not as such overrule past cases, but the approach adopted was based on whether enforcing the claim would be harmful to the integrity of the legal system and contrary to public interest. It focused more on whether the claimant should recover or not, on the basis of broader considerations reflected in a range of policies and proportionality tests. Additionally, it may now also be that there is no need to invoke a locus penitentia rule, since the balancing approach accounts on whether the illegal purpose has been fulfilled. The method of analysis now is that courts must determine the fact of enforcing a claim tainted with illegality, namely the trial of considerations. First to consider is the purpose of the prohibition in question, which has been transgressed, on any conflicting relevant policies, and thirdly, the need to avoid a result that is disproportionate to the legality. This approach on the legality principle has been carried out in recent cases, and there was a comprehensible application of this range of factors test in the case of Sungai Lewis Holdings Limited against Daiwa Capital Markets in 2018. And among the issues raised here was whether a defense of illegality was available to defeat a claim in negligence and breach of contract by the defendant stockbroker. In particular, the Supreme Court rule looked at the matter at hand and the material impact it would constitute if the claim had not been allowed. Accordingly, an illegality defense was not available, as the established duty to the company would be undermined and would result in a disproportionate response. Here one can observe that the reasoning given by the courts highlights the challenges which financial institutions will now face to make such a good defense. Moreover, in the case of Staffel & Co. against Gondwana in 2018, it concerns whether the claimant, a participant to an illegal mortgage fund, could recover on the basis of the illegality principle. The Court of Appeal relied on an approach to uphold the previous conclusion reached by the first instance judge, hence confirming the prima facie applicability of the range of factors approach where an illegality defense was raised. The courts also overturned the basis on which the Supreme Court had relied on to make the decision, namely the reliance principle, thus also affirming that it was no longer applicable. It therefore shows that the public policy interest in clients being able to obtain civil remedies for the inadequate performance of professional services outweighs the undesirable outcome of allowing claims to proceed where a fraudulent transaction arises. Likewise, in the case of Robinson against Ness & Co., the claimant was allowed to recover damages from solicitors who had acted negligently, notwithstanding that the claimant was in breach of an enforcement notice. From the limited number of cases that have been discussed since Mirza, it is clear that the judicial function has already started to change in relation to legality. We see how courts have been allowed to take a discretionary approach on the individual facts of each case to assess broader evaluations about what is unfair, disproportionate, and contrary to the public interest in deciding a question of public policy. It also comes to light that the majority laid down a new approach applicable, but not just in criminal, but across the civil law. At the same time, a discretionary system based on the considerations of public policy was somewhat derived from this new approach. Due to this, some have debated about whether this new approach favors discretion and have sided to the more rule-based approach. There have been situations where, when illegality defense had risen, for it to succeed, it must be justified that it is reasonable in reference to the public interest. As have been explained, the majority ruling in Mirza has substituted the public policy rule on illegality, ex turbi causa, with a broader inquiry as to whether enforcement of a claim would be harmful to the public interest. Subsequently, unlike before, English judges are not allowed to introduce new public policies to justify their decision. And under the modern doctrine of public policy, English judges could only refuse enforcement of a claim as being against public policy only if the claim violated policies which were already applied into statutory or common law rulings. Indeed, it is submitted that although Mirza's fundamental change in judicial attitude to public policy is unlikely to result in the required coherence and legal certainty in this important area of English law, there remains a clear judicial desire to temper the rigidity of the ex turbi causa rule to avoid unjust results.
And Gwee Min Qi, the case of Patil and Mirza, emphasizes a more flexible test which involves the balancing of a series of factors. The majority of the Supreme Court held that the main rationale of the illegality doctrine should be that it would be contrary to the public interest to enforce a claim if to do so would be harmful to the integrity of the legal system. This new and flexible approach has included trial consideration and was adopted by the mentioned court of appeal case of Parliament, where the court held that when the illegality defense is raised, a vital and significant consideration is a public interest in the integrity and consistency of the legal system. The court of appeal refused to apply the relevant test and decided to adopt the new approach laid out in the case of Patil and Mirza. The case of Liputan Symphony Sendian Berhad referred to the decision of Patil and Mirza. The federal court considered and applied Patil and Mirza and found it a contract for the sale of land that has the effect of evading the payment of real property gain tax and reducing the incidence of stamp duty were nonetheless not void. In the case of Sawan Singh's Kudan Singh's, the judge observed that the Patil and Mirza can be reconciled with and accommodated within the scheme of the contract at 1915 by virtue of Section 24E of the contract 1950. One of the significant tests brought by the case of Patil and Mirza is the law has departed from rigid rule-based approach to a flexible series of factor approach. There is a debate on which approach should be adopted to a defense of illegality. In Brita, UK, Lord Nielsen PRC say it can be seen as epitomising the familiar tensions between the need for principle, clarity, and certainty in the law with the equality important desire to achieve a fair and appropriate result in each case. The judgment delivered by Lord Thompson in Patil and Mirza was to adopt an approach which is in accordance with upholding the integrity of the law and achieve an equitable result on the face in each case. This new approach brings an end to the fundamental state of law. The series of factors approach provides some structures in the analysis of the fact and circumstance in each case and enhance certainty and consistency which the public conscience test led. As Lord can observe, the advantage is that the courts are now spared from having to desire permanence and contract exception to previous formulation of the illegality rule. The latter approach adopted by the court when confronted with a defense of illegality in claim for recovery or benefit under contract tainted with illegality is a waiving of public policy consideration. It remains to be observed how the policy considerations will be prevented in influencing any decision with regard to the restitution of money or property. The interpretation of the trial consideration will be a key to the exercise of this new approach. The case of Teresa Chung and King Kong's suggests that Malaysia must follow only those head of public policy recognized as common law. Besides, there is also the suggestions to enhance Islam as a guiding principle regulating the public policy in Malaysia because it provides a better overall safeguard which includes a large circle compared to the common law classifications on public policy. Will it contribute to a worse situation or will it be a new mess to for an old one as the law being harmed? Not this. At least the old mindset of the court to draw out its circles and refuse all assistance to the plaintiffs, no matter how serious his loss or how disproportionate his law to the unlawfulness of his conduct has become a history.
Whether the new approach is settled or clarified the law, an examination must first be made in regards to the reasons behind the uncertainty of the new approach. One of the reasons would be the unsatisfactory conclusion of the case of Patil and Mirza itself, which left two major components of the law quite unsettled, leaving the law without a clear answer. According to McKendrick, the two components involve the nature of illegality and the right to recovery.
Firstly, the nature of legality has not been elaborated on much, with the words of Lord Towson stating examples of drug trafficking, which will be considered as an illegal nature that the courts will not allow such recovery. Another cause of uncertainty would undoubtedly be the trio considerations element, as established in Patel, that has done away with a more rule-based approach, such as the reliance rule that is often preferred for its certainty, consistency, and predictability, which, according to Professor Burrows, are important qualities for good law. With the reliance rule in Tinsley and Milligan no longer relevant, the new trio consideration approach is now the priority of the judges, where everything will turn on their interpretation of the trio of considerations, which, as criticized by Professor Graham, puts the law on illegality 2 steps back by introducing an unacceptable uncertainty in the operation of this defense. The reliance of the new trio of consideration also makes it hard for lawyers to advise their clients of the likelihood of the outcome of the case, as it would be dependent on the facts and circumstances of each individual case. It is also argued that the courts are neither competent or constitutionally mandated to take on the role of balancing policy factors, and the role of development of the law that involves policy is best left to legislation. However, Professor Burrows, who is in contrary to this view that he called policy minimalist, commented that the development of the common law is unavoidable and can be trusted in the hands of experienced judges. The democratic view of the people will also not be infringed, as we know that the legislature can always choose to override the decision of the judge should it wish to do so. Despite the multiple criticisms regarding the uncertainty of the new approach, it should not be assumed that the law is uncertain. It is submitted that the old approach before Patel and Mirza is in itself highly unsatisfactory and often been uncertain, with the court's desire to depart from patently unsatisfactory rules. The rigid rule-based approach, primarily the reliance rule, does not take into account a range of factors, making it an unsatisfactory approach. The reliance rule is arbitrary, and although it is often seen as a rule-based, a more certain approach, critics argue that no one is entirely sure what it means or what its justification is, and its formulation is unclear. On the other hand, while an approach is flexible, it does not mean that it is uncertain. The new approach is more transparent in comparison to the old approach, as the consideration of a range of factors illustrated a more transparent approach, as highlighted by Professor Burrows, which ensures that the courts reach the best decision on defense of illegality possible without the restraints of a more rigid rule-based approach. Furthermore, it should be noted that the law has not been completely transformed into an uncertain one, as the new approach is based on specific issue on the claim in restitution, where contract is tainted by illegality, and it did not completely eliminate old law, which was still applicable, as illustrated in Henderson and Dorset Healthcare, where the decision is based on older case of Clunies and Camden and Gray and Thames trains. Here, the Court of Appeal highlights that considerable caution must be taken in determining whether Patel Mirza has impacted different areas of law in illegality. It is also emphasized that appellate's court is limited in interference with the trial court's decisions with multiple factor approach, and should only interfere when the first instance judge has proceeded on an erroneous legal basis, taken into account matters that were legally irrelevant, or failed to take into account matters that were legally relevant, as illustrated in the case of singularity. Approach that requires multiple policy consideration did not make the law more unsettled, and has actually made the law in the UK more certain, as it served as a guideline in steering the law into a more satisfied approach, providing more space for development of law of illegality. At the same time, it did not affect the past laws, and the old laws are not thrown away completely. Therefore, it cannot be said that the new approach has in fact steered the law into a completely new and unknown direction. Based on these reasons, it is submitted that the law on Patel and Mirza has in fact clarified and settled the law on illegality.
My name is Hasya Aqilah. The issues revolving around the illegality defense were finally addressed by the United Kingdom Supreme Court in the decision of Patel and Mirza. Now, let's look at how this decision has affected Malaysia and whether the law has been settled. I will be using the judgments from some of the Malaysian cases to support my stand that the law in Patel and Mirza does clarify the law in Malaysia. I would like to start off with the first case that followed Patel and Mirza, which is Pang Mun Chung and another, and Cheong Hui Charn. Although the decision in this case does not make it clear whether the pre-Patel case law has been overruled or not, it's still good law in a way that the trio considerations are relevant as stated in the Supreme Court of Canada in Hall and Herbert. In doing so, the Court of Appeal agreed that the factor-based approach is consistent with upholding the integrity and harmony of the law by achieving an equitable result based on the facts of each case. Another case that follows Patel and Mirza is the 2019 case, Liputan Simfoni Sdn Bhd and Pembangunan Orchid Desa Sdn Bhd. Here, 6 parties were involved: the plaintiff, which is Orchid Desa, director of Orchid Desa, first defendant, which is Liputan Simfoni, second defendant, Chansit, third defendant, Pendaftaran Tanah and Galian Wilayah Persekutuan Kuala Lumpur, and the imposter. The imposter entered into a sale and purchase agreement with the second defendant. This is known as the first sale purchase agreement. And later, the second defendant entered into the second sale and purchase agreement with the first defendant. The High Court held that the second sale and purchase agreement was void pursuant to Section 24 subsection B of the Contract Acts 1950. Court of Appeal agreed with the High Court that the second sale purchase agreement was void because it deprived government's revenue. Hence, it was illegal and unenforceable on the grounds that it was contrary to public policy. Under Section 3 of the Civil Law Act 1956, it states that Malaysia is allowed to follow common law as long as our respective inhabitants permit and subject to such qualifications as local circumstances render necessary. In the case of Lorry Malaysia Berhad, the federal court stated that we should follow common law when the action seems sensible. The law in regard to courts should slow to find illegality and strike down commercial transaction is a sensible one and should be followed, thus incorporating part of our law. Adding on, the courts found that the test laid down by Lord Towson in Patel regarding trio consideration is a sensible one. Hence, Patel was accepted and followed in this case. It would be an overkill for the first defendant to lose the subject land for the infringement of the two acts, which is punishable by a fine upon conviction. The case of Dr. H.K. Fong Brain Builder and S.G. Mat Sdn Bhd and others did not follow Patel and Mirza. Instead, they relied solely on Contract Acts, Section 24 and Section 66 or 71. The court stated that they did not follow Patel not because they disagree with the decision or regard them as bad law, but because the provision in the Contract Act itself was sufficient enough to solve the particular case. So we can conclude that although some Malaysian cases did not follow the new approach introduced, it is still considered as good law under illegality. Next, the issue of illegality was not discussed in the Court of Appeal case of Muhammad Iftitah bin Ismail and Datuk Hassan bin Malik. However, the Court of Appeal judge Hamid Sultan delivered his judgments by stating that the issue of illegality and public policy in Patel and Mirza is instructive. This shows that the Court of Appeal judge Hamid Sultan agreed with the law applied in Patel. These recent decisions of the Malaysian Federal Court and Court of Appeal, as shown above, clearly indicate that Malaysian courts have departed from the long-established traditional approach, and therefore, I would like to conclude that the law in Patel and Mirza has made its clarification under Malaysian law in regards to illegality. We would like to conclude by saying that the law in Patel and Mirza introduced the new approach to consideration of public policy. This new law has brought a remarkable change in the doctrine of illegality, which will now affect the future cases. The decision in Patel was based on a flexible structure approach which considered both the policies and proportionality. The reliance rule that was wrongly used in Tinsley and Milligan was rejected for a good reason, as it does not have universal application and it could produce different results according to procedural technicality which had nothing to do with the underlying policies. Despite all the criticism received from the minority judges and public, the courts should not be reluctant to use this method as it does indeed clarify itself in English and Malaysian law. In short, the new approach in Patel and Mirza has settled.